So, Phil, the first one I want to talk about today comes out of our own Eighth Circuit Court of Appeals just in the last couple of days here. An employee, this is out of Arkansas, not Missouri. I want to make it very clear, but it is still out of the Eighth Circuit Court of Appeals. And what the court held in this particular case is that the employment at will doctrine supported an employer's decision to discharge an employee who had THC in his system. So we all know that we've talked quite extensively on this program. Phil, you and I've done a lot of other programming on what I like to call the right to weed. In Missouri is a right to weed state. Employees have the right, or individuals, I should say, have the right to use both medicinal and recreational marijuana in the state of Missouri. The hard part comes in when we have to start figuring out what it means to be under the influence of marijuana at work or THC at work. And that's kind of, as we've said before, that's where the rubber meets the road. What does it mean to be under the influence? And this particular employer in Arkansas tested an employee, and the employee tested positive for THC. The employee did, in fact, have a workplace injury, had been treated for the workplace injury, and claimed that they were taking the product containing the THC as part of their treatment. But the Eighth Circuit Court of Appeals said, look, the employer can have a policy that says you may not be under the influence of marijuana or THC at work. This employee was, he was tested, he tested positive. He then admitted that he was using THC, this medicine, and the court upheld the firing of this employee. So it's just a reminder, Phil, I think we've talked many times before that rather than just relying solely on testing, it's our recommendation that employers be trained on what we call the indicia of impairment or indicators of impairment. Having substantiation of those indicators of impairment and then getting the positive drug test, I think you're in a much safer position to terminate an employee. I don't think it would have ever gotten to a trial court or certainly to a court of appeals if they had done things a little bit differently here, but the employer did prevail. So I just want to mention that.
Yeah. So Burt, in the case is Arkansas a medical marijuana state?
You know, I knew you were going to ask me that question, but I didn't look that one up yet. I'll see if Amy Hart can tell me real quickly. Marijuana is a medicinal marijuana state, but not recreational.
Okay.
But again, even medicinal, the employee still does not have the right to be at work under the influence.
And I think in this case, what they're saying is he was impaired.
Correct.
It wasn't just that he had a positive test.
That's right.
Facing complex employment law challenges? As an AIM member, you get direct access to Ogletree Deacon's top attorneys for expert guidance and defense. Call AIM at 800-948-5700 or visit aimea.org to engage expert workplace specialists today.